On the principle of prospectivity, we need to pay attention to the general rule that penal laws cannot make an act punishable in a manner in which it was not punishable when committed. That's how it was laid down in the Book 1 of Reyes. It says that no ex post facto law or bill of attainder shall be enacted. This was already mentioned in my previous lecture, in the previous sessions, particularly emphasizing on Article 3 of the Philippine Constitution. Now, what is the exception to this rule? The exception is when the new law is more favorable to the accused then it can and it should be, it can be applied retroactively. No, pwedeng yung nakumit niya na crime for 2007 was with a penalty of, let's say, up to 40 years, but because of a new law this year, amending or not necessarily amending, but saying that the penalty should be less than 40 years, say 6 years, then it can be applied retroactively in favor of the offender. So kung na-serve na niya yung 6 years, then he should be immediately released. But there is also an exception to the exception, which are one, when the new law is expressly made to be inapplicable to pending actions or existing causes of action. Talagang sinadya na hindi i-apply. Okay? It's an exception to the exception. Or the second one is when the offender is a habitual criminal. So hindi po pwede kasi paulit-ulit eh. So if you serve it to his favor, there is a tendency that he will commit the same and be punished for the same. No? So habitual criminal, or can be another offense. Pero, point there is lagi siyang nagko-commit ng crime. Okay? The effect of a repeal or amendment of penal law can be an absolute repeal, which may be expressed or implied. It can also be a partial repeal or a self-repeal. No? In the case of Republic Act number 10951, or an act adjusting the amount of or the value of property and damage on which a penalty is based and the fines imposed under the RPC, it actually amends several provisions of the RPC. Substantially, the amount of fines to be imposed for crimes, as well as adjusting the basis of penalties, which are determined by the value of the property damaged by the crime. And it was signed last August 29, 2017. What do you think are the effects of such repeal or amendment of the penal law? So, if the new law makes the penalty lighter, it shall be applied to pending actions, except if the offender is a habitual delinquent, or when the new law is expressly made inapplicable to pending actions or existing causes of actions. If the new law imposes a heavier penalty, the law in force at the time of the commission of the offense shall be applied. Also, if the new law totally repeals the existing law, making the act not punishable, then the crime is obliterated. So now you ask the question, what happens or what is the effect of an obliteration of a crime? Obviously, if it's a criminal case pending in court or still pending in court, the case shall be dismissed since the court loses jurisdiction to try and decide in view of the obliteration of the offense from the statute books. When the case is heavily decided by the court and the accused is um, the point there is the court has already made a decision and the accused is serving the sentence, he shall be released from detention for the same reason that the crime is obliterated and there's no basis in the statute books. If the criminal case is not yet filed in court, it can no longer be filed since the act no longer constitutes a crime. Okay? Hindi na pwedeng i-file against the person committing such acts. The case of a partial repeal, ang mga epekto nito is that if the repealing law penalizes the same act punished by the repealed law, then the court retains the authority to try and sentence the accused under the old law or the law existing at the time. However, if the same act is punished by both the repealing and the repealed law, and the penalty provided by the new law is lighter, then the accused shall suffer the penalty that is provided in the new law, because a penal law may be given retroactive effect when it is favorable to the accused, provided that he is not a habitual delinquent or that the new law does not prohibit retroactivity. Another effect would be if the new law makes the penalty more burdensome, then the heavier penalty under the new law cannot be imposed. So these are the basic points that you have to remember in understanding the principle of prospectivity. So you can go back and try to uh, listen again to the lecture when I was discussing the ex post facto laws, and also when I was discussing about the penal laws that are favorable to the accused. So that's specifically located in Article 22 of the RPC. But we'll go more into details on the specific provisions of the RPC in the coming sessions.